benefit of the Horry County Clerk of
You
Court.
have a way to make a copy there, but I can hand you my copy. And, I have listed 13 motions, and we've talked about several of them. I think we can just get cleaned up real quick.
Yes,
I
sir.
like that.
Yes, sir.
You make 2 of those, Liz? One for the judge and one for you.
Do you have are they on your roster, Judge?
Yes, I have a written roster like you've got, and I highlighted the sections of that.
Well, I did that.
You want your printer, dude, you're not that deep, are you?
Is that this, but this is the same deal?
Yeah. I start at case number 20.
Well, mine starts with number 16, first motion is number 21.
Everybody else do. I see 22, it's a B motion.
Yep. Okay.
My first one is case number 21, that goes through to like 29.
Yes, okay.
So these are the filing dates and the number of motions that I show are outstanding. And I think we can resolve a lot of them. The notes I scribbled are here in the courtroom when we were talking attorneys and I, so.
All right. Let's let Mr. Kennedy go through what he thinks has been done, and then the other lawyers on my right will decide if y'all have actually resolved those.
Well, I was gonna try to do it from our roster, so we can mark.
That's what I'm working off of. I've got Mr. Moss's 13, and it certainly was hard to find some degree. But on the court's roster, this case is motion 21 starting there.
Yes, sir, I believe that's moved.
Is that the motion to help clients from the county as well?
I believe so, Kenny. It's the same filing date.
I believe that's moved too, Your Honor.
Excellent.
All right. The second one was the stand your ground hearing, so we're not doing that today.
That's 22?
Yes, sir.
Okay.
And I think that the 23 is the same. He filed it 2 ways. I believe it's I'm sorry, one's Boyd's and one's Williams. So that's the stand your ground hearing.
So it's 22 and 23 are both the hearings.
Yes, sir.
The same hearing, other than, but really.
Correct.
Okay.
So that's the defendant's motion to quash our subpoenas for medical records. They're going to withdraw that with a stipulation. I'm sorry?
We did a confidentiality deal about what could be
Yes,
utilized.
but since he wrote the providers, what we're going to do is submit a proposed order saying it's been withdrawn and directing those providers to answer. Everything that they answer will be designated confidential.
Okay.
So we'll put that order in your queue.
That's the piece our confidentiality order did not address, was I had to mark it confidential if it was gonna be triggered through that order.
I remember this discussion, I didn't know how y'all resolved it.
I don't mind if they respond as long as we have a stipulation of whatever they provide us under the guise of a confidentiality order.
And those things may or may not be introduced in the stand your ground here, that to be decided later.
Yes.
Right.
Okay.
So number 25 is our motion to compel, and I think the only thing left is the same deleted Facebook messages we talked with you about in Lawrence. And the answer is they're working on them, so I don't know how many days they need, but, which gets to our scheduling.
Yeah.
All right, let's hear.
This is Boyd's.
Boyd. Okay. The same request came for Mr. Boyd's deleted messenger communications and Mr. Williams. Attorney Lee hired an expert to assist Mr. Williams in obtaining and providing
His Facebook post,
for his Facebook post.
and you're working on,
I'm using the same expert trying to get him for Boyd, but
Okay.
he was going out of town and he told me he couldn't do it for 2 weeks, and so I'm gonna try to get the same thing. Theoretically, there'll be the same messages, just in the middle of image.
this is a conversation with them talking.
Correct. So I don't expect anything revealing to come from that, but I have asked, and the experts told me when he got back in town to do it.
Young Mr. Martin.
And I've been called worse. We do have Mr. Boyd's messages. They are at my office. I will put them on a flash drive, and I'm going to try to get them to him before he leaves town today.
Mr. Williams' message.
Mr. Williams, I apologize.
And that's fine, Your Honor, but as it relates to Mr. Boyd, I think the request is a little broader than just Kenneth Williams' deleted messages. So, I mean, I don't care, but if they're also talking about December the 15th, we're running out of time.
Yeah.
So, I mean,
But you're getting Williams for it today, and at least Boyd, same experts working on, correct, Mr. Moss?
Yes.
Okay.
So can we do an order and you'll get them to me in how many days?
Well, you know, anything I tell you is gonna be depending on what the expert does, but I think when he got back in town, he said he could do it pretty fairly quickly.
When's he coming back in town?
He should be back this week,
Okay.
so I can report back to Your Honor well, it was 2 weeks when I talked to him, but it was been 2 weeks ago since I talked to him. I was trying to have it done before today.
Well,
So I'm happy to call him and report back to y'all, but I'm thinking 10 days would be reasonable.
If he needs more time, Judge, we can address that, but 10 days and I will.
we talked at a hopeful target. I'm not assigned here yet, but switching court with another judge to come back down here mid-December. Are we still on that target?
I hope so.
We would like that, Judge.
I don't see how we're gonna make it. I mean, we're going December the 1st to do Frank McMurray. We can talk about all that, but
Okay.
I mean, if we can make it,
I
I'd love
hope
it.
you get it done as fast as you want.
Yes,
But, if I need to sign some stuff, Rattling Sabres will do it. Don't mind helping.
Well, again, what we do here today may impact some of that, but our position on behalf of Mr. Williams is that we would like to move this forward as quickly as we could. And I think a month from now, if we will get our act together, everybody can have what they need to let you hear this stand your ground motion.
All right, and like I say, I mean, the expert, it's a big machine, a lot of moving parts, and so I'm not.
It is, and we got to get a date, and then we got to be sure we can get our witnesses here for that date.
Okay. All right, keep going down, Mr. Tinsley.
yes, sir. So number 26 is a motion to stay by defendant Williams. I believe that's been
We
withdrawn.
withdrew that in Lawrence.
And that's, we're pushing on this hearing now.
You're right.
Yes, sir. So number 27 is withdrawn, but basically, we're gonna submit a proposed order to Your Honor, same as with the other healthcare related records.
That's a mirror image type
It's
thing.
different providers, but yes, sir.
Okay.
Number 28 is we're gonna argue today.
Okay.
And then number 29, I think Kenny, is number 29 withdrawn?
Which one is that?
I think that's the therapist records, and then she's indicated that she's not gonna respond. He had written, so if he withdraws his
We
motion.
discussed this in Lawrence, I
I gave
remember
you
there were
that.
some issues.
She gave us those two synopsises,
Yeah.
and, but she has indicated she's not gonna comply with the subpoena without hiring her own attorney and challenging that. If you recall, she gave us the two synopsises.
Yes.
So, she wouldn't give them to me.
Judge, I understand she may have provided those records to one of their experts. I'm gonna subpoena that expert to see if we can get them without having to drag her in, but other than that, we'll just have to schedule a rule.
Okay. Fair enough.
I think that's all.
All right, Mr. Moss, we're going through the inventory of pending motions somewhere, and Mr. Moore, could anybody else?
Well, and I'm looking at my sheet, not the court's roster, but the protective order motion was filed on July 8th. This one, there's been an order entered on that one. So, there's two motions to compel against, defendant Boyd. One pertains to this information they want from messenger posts and deleted, and I've engaged the expert. The other pertains to other responses that I think have been fully complied with, which I've written and asked, and I've not received any notice, any
That's
deficits.
number 4 on your list, the response to interrogatories are compelled.
As far as I know, we fully responded to those, and, in the, back and forth with Mr. King's office, we invited them to tell us if there's anything else they don't think we have, and we don't have any communication other than these text messages that, or messenger messages that we're talking about hiring an expert for. Other than those, I think we fully complied.
What do you think, Mr. Tinsley?
I think that's right. I mean, in the request for production, there's a protocol how he would download that information, but that's the main thing I'm arguing about currently. It's the only thing I know.
Okay, so the messenger Facebook stuff's the one you're waiting on.
Yes,
So there's two motions to compel, but only one of them is relevant to that, those
Correct.
that we're waiting on.
So, number 4 on your list, the discovery responses you believe other than the messenger have been complied with sufficiently. Ms. Kinsley?
I believe so.
Okay, that sounds good
Let me
to me.
get number 4 real quick, and see if I. Yes, yes, we're on the same page.
Okay, all right, good deal. Mr. Martin, what you say?
I'm in agreement fully with what they've said so far.
Well, and the two most recently filed pertain to our subpoena of the plaintiff for her communications with third parties. And also our subpoena for records related to the fee agreement and the fees incurred and costs incurred specifically by the plaintiff because they've asked for it in their summons complaint. As to the former of those two, you know, we're perfectly fine standing that down until after our standing ground hearing for the we'll need it if we have to try this case, but we don't need it for the standing ground hearing. As to the latter,
Let's divide and conquer, let's keep getting,
as to the latter motion, which would be the most recently filed motion, I don't think there's any cause of action pled that would entitle the plaintiff to any recovery of attorney's fees and costs under the cause of action alleged, and I think that's kind of the response I got. But if we have that stipulation, then we can withdraw that motion.
well, we can do the whole thing later. If we get standing ground here done and see what's left, what's going to either go forward or not,
Right?
then we'll know.
And that will be the last two. We're perfectly
And so
fine.
standing ground goes either way, that's gonna be determined of a lot of things.
Right,
And
so
standard's gonna go one way or the other, I mean, it's gonna be granted or denied, I mean, I'm not gonna say maybe.
those last two motions, they're Boyd's motion, and I'm perfectly fine with putting them out in the future after we have standing ground
Sure,
hearing.
all right, yeah, that's, we can deal with that after the standing ground here. There's more to come after that goes that far. Okay. Yeah, I'm with you. All right, and Mr. Martin, what you got?
Well, Judge, I think,
We're gonna do that in
our motion to admit the 911 call and other statements of Blaze Ward and Frank McMurray are, you know, that hasn't been discussed, and that's something we want to deal with today. I think everybody needs to deal with. And that'll be instrumental in determining when we can have the hearing. But
And if I remember, those are the two witnesses that live out of state.
yeah, I'll go back and brief you just a little, it's in the Lawrence. There is a Blaze Ward who lives in North Carolina, she is a young lady. And then there's a gentleman named Frank McMurray, who is from Virginia. And both of those have gone silent underground on us, for whatever reason. We've tried, I have tried periodically to reach out to both of them by telephone to no avail. And so I know Mark has a deposition, trying to get a deposition, Mr. McMurray. But be that as it may, those two witnesses are integral and they're important, and they both did three things. They both made a 911 call, and they both were interviewed by police officers at the scene with a audio/video recording, and they both made written statements at the request, I guess at the request of the police officers, but they both gave written statements. We believe that, first of all, the 911 calls are clearly admissible under Rule 803 and the case law throughout the state of South Carolina, as they do comply with the requirement of the courts and the statute. We believe both under 803.1 and 803.2. And we've got those calls, recordings for you to hear. Is that not, if you want to hear those in regard to this, but those were, by the way, just to, so you will know, Ms. Ward, statement was that she was traveling down Highway 9 for the length of this 9 mile, I believe they said, trip. And that she was there early on, and she was there at the scene when the shooting occurred. Mr. McMurrow is an individual, if you'll remember, both parties were traveling from the North Myrtle Beach area to the Dolores area.
Because they were headed west.
The white truck and the black truck, and they were headed west, not following each other as far as we know when this started at least. They're both traveling west. Ms. Blaze Ward's doing the same thing, along with multiple other witnesses. And then when they get to Camp Swamp Road, the black truck, Mr. Spivey, turns right, and the white truck with Mr. Boyd driving and my client, Mr. Williams, in it, turns right. That's where the shooting occurred. If you recall, Mr. Spivey, for reasons satisfactory to himself, stopped in the highway. And then Mr. McMurrow's testimony would be about that. He is coming down this Camp Swamp Road out to number 9. So as these trucks are parked this way, he's coming this way.
He's headed toward.
Number 9.
Number 9 in Myrtle Beach.
Yeah.
He's going down to North Myrtle Beach. And I'm not.
He's headed south.
Yeah, he essentially says, and not that this is exactly what was said, but to give you an idea, I'm coming by, and my wife said, Lord, there's somebody who got a gun. The black truck stops, that guy jumps out with a gun, the white truck stops, and I'm driving by, and the next thing you know, I hear shooting. So he is an important witness with regards to that. And then Blaze Ward, again, she had come from North Myrtle Beach, and she was actually going to turn down Camp Swamp Road to go home. She's behind the black truck, behind the white truck. And then, so she is on 911, on the phone with the 911 operator, coming down Highway number 9, talking about what she's observing, and it clearly an excited tone that there's a man with a gun pointing at me and other people. And then Mr. McMurrow, again, he calls 911, as far as I can tell, just as soon as the car stopped that he was in order to alert them as to what's going on. As a matter of fact, there were probably 4 people that called 911 that day in connection with what had happened. But we believe, obviously, we'd still like to get these witnesses here. But, you know, you told us in Lawrence, write them a letter, see what you can do, and they've stonewalled Mark, as far as I know, as well as us. They just don't want to cooperate. And so
We made suggestions to reach out to somebody that may know them, another lawyer that may know, all sorts of different ways to try to nicely approach them.
well, there is, and we've called, and let me just say that Ken, just Saturday, I was with Ken, we called Blaze Ward. And for the first time, her mother answered the phone and said that Ms. Ward was busy with her child, feeding, bathing her child, and she really didn't want to talk about this. And
She's a little more assertive than that, Judge.
yeah, but Ken, I was there, and he said, well, listen, we understand that, but you know, there's some things coming up, there's probably some things she needs to know, we'd like to talk with her. And I'll give her the message, and there's been nothing else. I've even thought about driving over there, but I didn't want to get shot either, so.
Well,
I'm
she
like-
lives closer by than McMurray.
Yeah,
He lives out in
she's probably, I don't know, 30 minutes, an hour from here at the most. Yeah, and McMurrow is really hostile about it. People have tried to go serve him, and he's threatened to call the police or do things to people. I don't want to misquote him, but anyway, he's hostile, okay, he's hostile. Now, as far as you know, Mark, the deposition hopefully still on with him December 1st.
He's been served.
So who knows what he'll do.
Yes, I'm going there.
But our point is, Judge, either way, their 911 calls, which we're prepared to pay for. And I think certainly their written statement of those two are admissible under 801, Rule 803, 1 and 2. And this is not a new question, it's been before the courts before, but it's a classic case of where what happened here are the elements that are required to allow the statements in as excited utterances and/or / present sense impressions. So we would like a ruling from the court as to their admissibility so that we can plan who we will have for witnesses to the court. So I can argue that as long as you want me to.
I understand your argument.
But it's clear. It's a classic case of excited utterance and present sense impression. I can't think of a better one, frankly, from our position with regards to Blaze Ward and, frankly, Mr. McMurray. And so with that, I'll answer any questions the court had about it. And again, if you listen to the 911 call, you'll see that startling, excited, in the moment, meets all of those 3 requirements under the case law and the rules, and they're all met. And so we'd be happy to play them for you. And those statements that I spoke to you about, Blaze Ward, we've got copies of those for you too, so you can see how they correspond or relate to each other. And Mr. Murray, that top one there as well. So, Judge, can we play those 911 calls for you?
Before we play them, I wanna hear from Mr. Tinsley, because it somehow helps me. You said everything's in there, he may say everything's not in there as far as, I wanna know what I'm listening for. And so I wanna hear his fight before I listen, and I'll be listening for whatever y'all are saying I should listen for.
Yes, sir. So, do you have a copy of the printed motion where they have the transcripts? Because this may be the easiest way to do it.
I have a memorandum that we had filed with the exhibits,
With the exhibits?
and I do have, I think I have that.
And I will answer that in the negative, I don't have anything.
Okay.
I have what y'all
What do you
given
want,
me.
Martin? Him to have a
Y'all
copy
gave
of
it
the
to me in
transcript?
Lawrence, I don't have it with me.
So we didn't give it to you in Lawrence, Your Honor, but here's what he's talking about. I filed back in July, I thought we might argue with him, a motion in limine on this issue, and then we had a memorandum of law in support of it, and attached to the memorandum were transcripts, written transcripts of these calls. We took the calls that we received in discovery, I hired a court reporter to transcribe them, and all that's in this bundle.
Okay.
And I got a copy here, we got one.
We've got copies, so this is exhibit 2.
Exhibit 2,
You're gonna get him a copy?
I've got to. You know what, let's do it this way.
You can have this copy we've got.
Let's do it this way. Judge, this is not for you today, but on the standing ground issue, Attorney Tinsley and I talked numerous times. He contemplated, we file a memorandum, he could give it the time to respond to it, which I'm fine with. I brought that memorandum to you, and the exhibit numbers are the same.
Okay.
So if I gave you this notebook, when he refers to exhibit 2, it should be the same, and I believe it's going to be the transcript of a call with Frank McMurray.
And the idea is when he responds, he's gonna refer to the same exact exhibit numbers.
Yeah, I tried to track the exhibit numbers the same through my memorandum and through this ultimate issue.
Okay. Is that your understanding, Mr.?
Well, he hasn't seen.
It's clear as mud, Judge.
He hasn't seen it. But this is your notebook.
If you respond to his,
Yes.
you're gonna refer to the same exhibits by the same number that he's already created. So if it's a statement by a witness to exhibit 3, you're gonna call it exhibit 3.
Yes, sir.
Oh,
And not reward him for me.
Exhibit,
In that notebook, you'll see the memorandum,
Mhm.
and the memorandum's organized with a condensed statement of 3 or 4 pages, and then a more lengthy statement. And there's also a table of exhibits. Well, those exhibits are the same number that I used in the motion before you right now.
Okay.
And Judge, just so you know, we, on behalf of Defendant Williams, we prepared a much more brief and concise recitation of what we feel the law and the facts are. The exhibits that'll be referred to in that will correspond with Defendant Boyd's as well.
Okay.
So the exhibit numbers, we're committing to them, whatever their numbers you refer to them as the same thing, should be.
Yes. So Judge, what they really want you to do is they want you to say that we can use these transcripts or play this tape for you, and you can rule solely on that. So tell us in advance, is this going to be enough to satisfy our burden in the stand your ground immunity hearing? And you, as you said in Barnes, until you see it, until you have some context, there's no way you can bless what they're asking you to do. So that's the first problem. The second real problem is that case that Judge Hood messed you up on, State versus Dennis.
Didn't
Yeah, that's just, and just for the record, Judge Hood got reversed in that case. But McCarty and Dennis, the courts made very clear that you have to make findings of credibility. And you can't do that from a transcript. And that's one of the things that State versus Dennis goes into in detail. And they cite that Georgia case where the trial had been years before, 8 or 10 years, the same judge heard the testimony. And think about it for a minute. They condemned what Judge Hood did in your case, where both sides had an opportunity to cross-examine these witnesses. So all he was going to do is read black ink on white paper. But you can't do it that way. You have to see, as the court's made clear, the demeanor, not just in the presentation, but in the cross. So my first argument is that under State versus Dennis and McCarty, because you have to make detailed findings of fact related to their credibility, you can't do it the way they're asking you to bless. And you certainly can't do it here, heaven knows how many days before we're going to actually get there. But I want to talk about the hearsay, because they don't satisfy all the hearsay exceptions. There's a part in McMurrow, so I'm going to start. Exhibit 2 is McMurrow's 911 call.
That's correct, Mr. Moss?
Yes.
2 is McMurrow's call?
Yes, sir. And as soon as you get to page 9, from page 9 on, Mr. McMurrow begins to say what other people at the scene are telling him happened all the way back down Highway 9. And so the third element of either the excited utterance or the present sense impression is that you actually perceive the event. We got State versus Davis, which is 371 South Carolina 170, State versus Prather, 429 South Carolina 583, and Fowler versus Nationwide Mutual. And the court, in one of those cases, is a 911 call where I believe the mother is on the phone talking about the daughter's rape. But she didn't see the rape. He didn't see whatever it is. So once we get past page 9, there's nothing in that transcript that would be admissible. Now, it's unusual, right? Because this is you. This is not the people over here in this box that we're concerned about. But we're outside of the exception. So if you're going to use the first 8 pages, maybe I don't have a big issue with that. But the first 8 pages don't help them. They want what's after that. Now, Blaze Ward is similarly afflicted throughout. And in Blaze Ward, there are a number of iterations of her conversation. But every single one of them, and I can point you to them, every single one of them, she indicates that she did not, so this is, first one's Exhibit 7, page 5. She says, I'm assuming he stepped out. She's talking about Scott Spivey. There on line 15. I couldn't see him visually get out of the truck. All I see is the bop, bop, bop coming off the windshield. And she goes on the next page, and what she's describing is, because see, she is somewhere in the range of a half mile back down Highway 9. We can see her on the surveillance video as they're coming up. And so what she goes on to say is that what I saw was the glass dust coming off of the passenger side windshield. Well, that's Mr. Williams shooting. That's not, and there's no evidence, and she'll go through and repeatedly, at least 6 different times, says, I did not see Scott Spivey get out of his truck. I did not see him shoot. I saw the glass flying off the windshield, and she assumed that's what was happening. That is not what was happening. So there's nothing in her 911 call that would allow them to be able to stand on the truth of the matter asserted when it's demonstrably false. Both defendants have testified that that vehicle was not struck by any bullet from Scott Spivey. There's no evidence. There's no witness that here, and these 2 witnesses. Now, Mr. McMurrow says that Scott Spivey gets out of his vehicle, he's got his gun in his hand with the slide locked back. He moves, but Boyd's already aiming his gun and unloads his clip. He says that in the first 3 pages. Unloads his clip. So what they want you to do is give an advisory opinion and go ahead and bless what it is so we can do short circuit the truth here. And the truth is that Blaze Ward unfortunately thinks she saw some things, but she didn't see them. And, you know, in terms of their unavailability, I don't know if they're unavailable or not. We're going to get
Wasn't that kind of what we discussed in Lawrence is, let's make best efforts as
Yes,
a group. Whichever lawyer can develop a relationship and get them to come testify, the whole crowd will then get the benefit of that live testimony.
Yes, sir.
And that's hope is still there.
Yes, sir.
May fail.
I don't have that hope anymore, okay?
You've lost it.
Yeah, I've lost hope on that issue. And let me say, we are all for the truth coming out. That's why we want to have this hearing, so we can hear things that the witnesses have said. And we can get to the truth, as opposed to third-hand hearsay by ghostwriters, etc.
Well, all right, let me answer this.
But, okay.
Y'all know this is law passed down from the Supreme Court. And the gist of it is the trial court can consider testimony admissible and inadmissible, and somehow disregard the inadmissible and just rule on the admissible and be fair. That's what a judge is supposed to be able to do.
Right.
I believe you're referring,
And
I believe you're referring to Brown versus Allstate, Your Honor, and it's Court of Appeals opinion number 3065.
So allegedly, I'm supposed to be able to do that. Disregard the irrelevant, regard and discern the relevant, and make a appropriate ruling.
And I submit to you that in the stand ground hearing, which is a bench trial, the analysis is very different than maybe a jury trial where Mr. Kinley's concerns about the totality of what they said could be more prejudicial, I guess. But this is exactly a Brown versus Allstate issue.
Okay, I know that law.
And we think you could. First of all, if I'm not mistaken, what Mr. Tinsley was talking about in terms of Blaze Wars was a statement she gave to the police, not her 911 call.
No, it's in all of them.
Well, we'll play the 911 call.
But let's let him finish, and I'm gonna come back to you. I'm gonna follow his train of thought and come back to y'all. I see where the rub is, I believe.
Well, and I don't mind anything that has been determined that somebody was mistaken about, leave it out of the statement. Like Blaze Ward, you can read her statement different ways about who she heard shooting, who was shot, and what she thought was happening. Doesn't mean she's not credible, and it doesn't mean that she's not within the parameters of the rules which allow her statement. But let me go back and with her, she's coming all the way down number 9, and at some point she calls 911, and she is saying there's a guy in a black truck that's all over the place. He's erratic. He's pointing his gun at people. He's pointing his gun at me, and that's the truth. That's the truth. And get somebody. It's dangerous out here. It's dangerous out here. And then she does come up the Camp Swamp Road, and then she tries to explain what she saw there, what she thought she saw. And none of it is, it all is exactly where it ought to be in terms of a 911 call excited utterance. As to the credibility, surely you can judge the credibility of the witness by the state she made. You don't have to look at a witness and see if they're squirming or one way or the other. And I challenge you, McMurrow, Blaze Ward, listen to it. and you will leave with the impression that that at least Blaze Ward is the last one I listened to, that she's telling you step for step what's happening. She's excited, she's startled, and she's scared, frankly, scared. So, and I do, and I'm talking about the 911 call first, and I'm talking about the statement I handed up, not the police interviewed her as well. Maybe that's admissible, maybe it's not, but in that one, which I wish the court could hear them all. I'll say that, I wish the court could hear everything. I wish you could get Blaze Ward here, Monica Wright, Terry Wright. These are other witnesses to what's happening down number 9. And I promise you, the truth is what we want out there. That's what we want. If we can get Blaze Ward, love to have it. We can get Frank McMurray, love to have it. But that doesn't mean nothing takes the place of that 911 call that Blaze Ward made. And so we believe it's admissible under the rules. It's particularly admissible with that Brown versus Allstate and the fact that this is a hearing before the court. So if we want to cut through the BS, and I promise you that's what we want to do on behalf of Bradley Williams, is to get everything we can that's relevant out there, let you hear it, and we'll live with your decision. But as this thing goes on and on, as you may know, it takes a life of its own with iterations and interpretations and speculations of those who may well not really know all the facts. So I'm expanding a little bit, but I do think that it's important that you hear these 911 calls and that they are admissible, even if we get the other witnesses here.
Okay. Ms. Tindall, don't you try to finish?
Yes, sir. It doesn't, you know, I don't know how you can in good faith say that you can simply rely on these 911 transcripts or calls when the Court of Appeals explicitly said where 2 lawyers cross-examined the witness, and you can read the transcript that Judge Hood was an error to have done that you can't rely on the transcript because you have to see their demeanor. You have to see how they answer those questions. I fully understand that you can discern what is admissible and reliable and what is not. They started with the exceptions to hearsay. They're the ones that argued these are exceptions under excited utterance and present sense impression, both of which require the witness to have perceived the event. What happens on Highway 9? There's some parts probably she could testify to, or we could play that, and it would be admissible under the rule. But she does not see the shooting, Your Honor. She does not see what happens on Camp Swamp Road. And that's the part they really want to use. And we know she doesn't because in every single statement, she says, I saw the dust. I didn't see him get out. 4, 5, 6 times she says that. It's in these various exhibits. I can give you page and line. So it doesn't qualify. You can't do it that way. And for as far as for purposes of today, where they want this advisory opinion, tell us how we can, that we're going to be okay, because this is all we got. Because their PI has hounded this woman, and she's complained to SLED, and Mr. McMurrow has complained to Virginia State Police about being harassed and hounded, and SLED is waiting on that complaint to then take it up with the licensing authority at SLED for the PI that's hounded these people. They can't make these witnesses unavailable and come in here and let us play, because she does sound terrified, no question about it. She is terrified, but she doesn't see it, and that's what matters.
All right.
I want to address one thing if I can.
Okay.
We haven't made those witnesses unavailable. We haven't done that. Our investigator hasn't done anything that would be tantamount to that. I haven't, O'Brien hasn't, and Ken can speak for himself. They haven't, and I don't really want to get into that. But if you want to get into it, it is all these podcast, social media statements calling Blaze Ward a liar.
Well, she didn't complain about that.
Well,
She
I
complained
don't
about
care
the
whether
PI.
she complained about it or not, but they know it's out there, and that's what scared them. So I'm not going to say that we scared them off. That's not true.
It's a complete
Not true.
clarification.
Well, here's the thing is, this case.
I think
If
that's
something
true.
caused it, what caused it, I don't wanna blame either side. We gotta get through either way.
And I hope we can get them here. I hope we can get them here.
I would like to touch on this issue because it's absolute fabrication by Mr. Tinsley. And I will tell you, both these witnesses, Mr. McMurrow and Ms. Ward, were very cordial and communicative with me prior to the deposition, the day of the deposition of Mr. Boyd and Mr. Williams. In fact, I prepared and mailed to Mr., and I told you about these transcripts. I had all these calls transcribed with the things. Because it's been a few months, I mailed all that to Mr. McMurrow so he could review them and prepare for a deposition. And we prepared for him to be deposed by Zoom on the same day that we prepared and we did depose, Mr. Tinsley deposed Mr. Boyd and Mr. Williams. And I called him during the deposition on a break. And I said, we'll get to you. It's supposed to, I think, be at 1. We're a little bit late. I called him. I said, we'll be with you in about an hour. And he was very cordial, very friendly on that break. I don't know what happened. I don't know who called him. I know that Mr. Tinsley and Ms. Hannah went out and they were on the phone. I don't know where the client was. But in that 1 hour time, I was ghosted. Because when it was time for his deposition, he wouldn't answer the call. And he could never answer the call from these things. Never once. At that time, okay, after he'd been so communicative with me for weeks, he ghosted me. At that time, we had not hired a PI to go find Mr. McMurrow. So it's complete fabrication to say that our PI had driven him underground. I'm calling BS on that.
But-
That is a bold-faced lie.
Well,
If it is, it's SLED's lie.
Well, no, that's not SLED's lie, because he went underground before SLED tried to contact me. SLED tried to contact me because they were investigating this conduct of the Horry County Police. They enlisted the help of the Virginia State Police to go see him because they wanted to talk to him for their own reason, not for this case. And he wouldn't communicate with them either. So it's not SLED's lie.
Well, it's obvious to me, these folks were responsible enough citizens to stop, call 911, make a report, stand by and get interviewed, and something, I think it's the heavy attention, has overwhelmed them, because that's not their normal understanding of what was, they had no idea of what was going on, or what was gonna happen, or what eventually. They just kinda got caught up in this huge interest in this case, and basically because of stuff that happened, I guess, later on.
Your
I don't
Honor,
know.
these podcasters, and I'm gonna call them tick trashers, they have berated these witnesses, called them liars, don't know why they would lie for Mr. Boyd, right on social media, even engaged Blaze Ward's social media account, said, y'all should contact her. Okay, that happened. And like it or not, those podcasters, those self-called journalists, I have a different word for them, they are tied to the plaintiff. And maybe tied to the plaintiff's attorney, I think they are, but I know they're tied to the plaintiff because she's talking to them and she's bragging about talking to them. Okay? That's who's doing them underground. And to somehow suggest that we've done that, or our clients have done that, or our client's investigator have done that, is a lie. And that is a Mark Kinsey lie.
Yeah.
That's not a SLED lie. But
Judge.
I haven't even had a chance to.
Well, here's the thing. I gotta consider this case, and y'all may not know the real reason that all this is going on. You suspect this, you think that, and you think that. We gotta put that behind us, of who started causing fear in these two witnesses. We gotta stop that. I don't want y'all to quit pointing fingers about that. We gotta deal with it.
Yes, sir, and for the record, Mr. McMurrow left before the first article, the first podcast. He refused to sit for his deposition before anything, anything. And so, you know,
I want, let's get away from why, because y'all don't know.
If I could touch on the motion at hand, I would appreciate it. Your Honor.
All right, I'll let you do that, but I want, y'all have got to quit pointing the finger at who caused the witnesses to get spooked or uncooperative. I'd love to see them come in here,
I would too.
and y'all would too. Y'all can't, you want 911 statements, he wants them in here, everybody wants them in here. I wish there was some way that we as a group, on behalf of families, the 3 families that are subject to this, plead with them to come in here. And the court would protect them as best they can away from, as best they can to have this onslaught of criticism from people that aren't involved. And that's what the for me, the tragedy is the people that aren't involved at all are criticizing, and they don't know the whole story. Once you're sitting here looking, you don't know. I don't know. I'm not listening to any of that intentionally. I've had people ask me, I heard you sign that case. If you heard this, if you heard it, I haven't heard any of it. I'm not listening to it. I don't want that. I want what I hear in this courtroom influencing my decision, not something outside the courtroom. So I'm not gonna listen to it. I don't have any need for it. Not gonna help me a bit. What's gonna help me is y'all presenting a good case, and I want to beg those two witnesses to please reach out, to come help me get to the bottom of this thing. And that's who it's gonna help. It's gonna help me, but it's gonna help the three families, the two gentlemen and the one gentleman, get closure. And that's what I'm looking for. Closure for each family. So if that gets out in the media, I hope it impacts them. They can contact my office by email, and I will assist them in being not subject to any criticism, if at all possible.
We do want the witnesses here, all of them. There are other witnesses that will testify as well, but these two, we think are important. We want them here. But regardless of that, we want the 911 calls and at least the statement that Blaze Ward and Frank McMurray made admitted into evidence. And that's what we're asking for you to deal with today. And a pre-trial motion, in limited, we think you can deal with that on an issue that frankly is just clear. Now, that don't mean we will stop trying to find Blaze Ward. I mean, I'll tell you, sitting through the courtroom, I'd spoken with Ken O'Brien last week about let's send a private investigator over there. I've thought about going myself because I think I can see it better than anybody I could see it, but I'm a little hesitant to do that with Ms. Ward there. Because we want them here. We want them here, but that doesn't mean we don't want a ruling on the 911.
Yeah, I want it all. Subject to rules, sure. All right, Mr. Moss, you have not been heard quite yet on this.
Thank you.
I've heard
I have,
Mr. Martin, then Mr. Tinsley, now you.
I prepared a memorandum and filed it. This is back some months ago. I've got copies here if anybody needs one. This is the copy for your honor. It is tied to the same exhibit numbers in that notebook. And there were some exhibits filed. But this is not new ground we're plowing here. Besides the utterances and present sense impressions are codified exceptions to the rule against hearsay. The case law that's cited in the memorandum really evolved through criminal proceedings where the concentration clause was at issue. We don't have that in the civil case at issue. And so to the extent there's a difference in the standard, our standard should be less. Okay? Because it's not a criminal case. But clearly there are admissible in criminal cases when they meet certain elements. And if you look through here, we have 911 calls and video recorded statements made to emergency dispatchers and law enforcement. That's what we're making this motion about. If we can't get the witnesses, we think they should come in. If you turn over on this memorandum to the fourth page, you'll see I've set forth the three elements for the present sense impression exception. And the first element is the statement must describe or explain an event or condition. The second element is the statement must be contemporaneous with the event. And the third element is the declarant must have personally perceived the event. And then I go into the balance of that page and I analyze exactly what Ms. Ward has said in her call. And it's clear from this analysis set forth in this memorandum, all these elements are overwhelmingly met. And we know exactly, Mr. Martin suggested she was in about a 9-mile travel that included these parties. Well, actually, she was in about a 10-mile travel because she was all the way back up at the Bell and Bell intersection where 57 is on the 9 when she first interacted with Mr. Spivey according to her testimony and according to her statement, not her testimony. And she actually says that he assaulted her with a gun and pointed the gun at her. Well, Mr. Spivey didn't encounter Mr. Boyd and Mr. Williams for some distance until the other side of Columbia Charter. And so from the stoplight at Columbia Charter to Camp Swamp Road, that is 9 miles. But Blaze Ward was engaged
At the car dealership.
at the car dealership. So she was in the path of travel for more than 9 miles. And over this call, when she says, hey, there's a guy out here pointing a gun, and wait a minute, and I quoted her in here, okay? The transcripts are accurately transcribed by a court reporter. What you can't hear in the transcripts is you can't hear her tone of voice. You can't hear the excitement in her voice. You can't hear the fear in her voice. And that's why we believe to really rule on this motion, you need to hear it. Because that demeanor is important to this consideration, particularly when it comes to excited utterance. But I have walked through painstakingly in this memorandum the elements, and what about her statement meets those elements? And I've done the same thing with Mr. Boyd's 911 call. Now, I'm assuming since he's a party, there's not an issue about the admissibility of his 911 call. Indeed, I think they'll probably want that, or parts of that, in his testimony. And I've also, in this memorandum, turned to the excited utterance. The excited utterance element, they have elements too. An excited utterance is a statement relating to a startling event. I'm on page 7 at the bottom. A statement relating to a startling event or condition made while the declarant was under distress or excitement caused by the event. And that's quoted from Rule 803, subsection 2, at the bottom of page 7. And it says 3 elements must be met for the statement to be excited utterance. Number 1, the statement must relate to a startling event or condition. We clearly must acknowledge that this was a startling event or condition. Number 2, the statement must have been made while the declarant was under distress or excitement. Well, clearly, if they're on the phone with 911 explaining what they're seeing contemporaneously with their observation, and they think there's somebody shooting in their direction, they're clearly under distress of that excitement. And the third element is, the stress of the excitement must be caused by the startling event or condition. That's 3 elements. And I'm citing in here State versus Stallnecker, which is a criminal case, in this memorandum at the top of page 8. And our appellate courts have said the rationale behind the excited utterance exception is that the startling event suspends the declarant's process of reflective thought, reducing the likelihood of fabrication. Now, what Mr. Tinsley has said to you is he thinks we want you to give us some kind of I wrote it down, pre-trial ruling or some kind of advisory opinion. There's nothing further from the truth. Here's what we're up against. You rightfully have urged us to give a date for standing ground here. We are almost a year and a half into this case. And the standing ground motion was filed first response to God. It's time. It's past time to have standing ground here. But in order for us to schedule it, we recognize that's our burden that we must present in that hearing. And we have witnesses who won't cooperate with us. Regardless of the reason, they will not cooperate with us. The last time I contacted Mr. McMurray by text to advise him we were having a court hearing, he texted me back and said, do not contact me again. And this is somebody who was cordially speaking with me when I was writing him and mailing him copies. So I don't know if we'll get him. I'd love to have him in the courtroom if we do. I'd love to know who contacted him on the day that Mr. Boyd and Mr. Williams was deposed and why he went dark on me within that hour. I'd like to know what his phone records say. I really would like to talk to this guy. But he's not cooperating. But if we're going to come to court in order to meet our burden, we have to prepare for how we're going to present our case, hopefully with those witnesses, but if they don't come, we've got to prepare our case without them. And so if we're in the contingent event of being without them, we need to know if we can rely on these statements.
Right, and your suggestion, or somebody's suggestion was, hearing would assist me in making a determination to whether it was excited, under stress, and all that sort of thing.
I think under these elements, these 3 factors for the present system impression and the 3 factors for excited utterance, I've done what I could in this memorandum and those transcripts. But until you hear, I mean, you really don't appreciate the excited nature of their voice and the hysteria in their voice. And so we brought them to prepare to play for you for this, not because we want you to roll a standing ground motion, not because we want any kind of advisory opinion or length or not. All we want you to do is tell us, can we rely on them when we come on December 15th and when we come, or can we not rely on them? Because
I understand.
we need to know.
I understand. Ms. Jenny, I want to hear them.
Yeah, well, I don't have a problem with you hearing them. But it doesn't change the fact that he says he's not asking for an advisory opinion, but then he tells you, can we rely on them? Both exceptions require them to perceive it. On page 7 of Exhibit 2, McMurrow's statement, in the 911 call, he says, "I'm calm now." He also says, "I talked to the driver," and then he begins to relay what happens back down the road. Blaze Ward repeatedly says, "I didn't see it. I didn't see him. I didn't see I saw what he looked like when he passed me back down the highway." She's terrified, Judge, but it doesn't change the fact that she doesn't see him shoot anything. She doesn't see it. So I think you will hear them, but I don't, as far as telling us today, yes, these are admissible, and yes, you're going to be able to rely on these, I don't see how you can do it, and I think it's an error of law if you relied on those in this stand your ground hearing to determine the credibility and demeanor of the witnesses as the court set out that you're required to do.
What case is that, Mark?
State versus Dennis and McCarty.
Under the ground, I'll state appellate case. The court empowers in the bench trial setting for the judge to make a decision on what he can rely on and what he cannot rely on. And I believe that you're competent enough to do that, and I believe you'll make a decision based upon the competent evidence. That's not what we're asking you to do today, make any kind of decision on the evidence. We're asking you to let us know in advance of our hearing today, because this is a motion hearing, that we can prepare our case to bring them. And if we get the witness here, great. But if we don't get them here, we still have a burden, we still have to go forward.
So, answer the question, the Dennis case is a case, and Mr. Tim is accurate. The appellate court reversed the whole trial, but it was a lengthy case in Lexington County, and there were 2 stand your ground hearings, and the reason why Judge
Russo.
Tommy Russo heard the stand your ground hearing because he was over the court in Lexington. He declined to grant stand your ground, and it got set for trial, and I was in Lexington. I heard the first trial in its totality, and it was a hung jury. During the trial, several witnesses testified watching videos of the youngsters, high school age kids, and there's a lot of phone video. Oh yeah, well they're so-and-so. The lawyers and investigators didn't know who those people were, and so there were 2 or 3 or 4 witnesses that were identified during trial number 1 who were not named or unknown names until trial number 1's hung jury said, "Wait a minute, let's go talk to them too, and we'd like a second stand your ground here." The second stand your ground here was presented to Judge Hood, and he heard all the new witnesses, and he read the transcript of Judge Russo's hearing, and he says, "No immunity, go forward." I tried the second trial in totality. Guilty verdict, and I sentenced the guy. He got appealed in the court order, which among circuit judges, you don't like to get reversed, but you like to get it right. Well, the reversal order said Judge Griffith reversed, but I didn't do either of the things that the court based reversal on. I just tried the case, hung jury, tried the case, guilty verdict. I didn't do either stand your ground here, but it was reversed for a mistake on the stand your ground here, not hearing all the witnesses the second time through in the second hearing. So it's kind of amusing to me that I get the discredit of getting reversed, but that's what we're talking about.
Congratulations.
That's great. But nevertheless, that's what Mr. Tins is referring to, is the opinion says that Judge Griffith was reversed when I don't think it wasn't.
No, as Judge Hood, clearly you screwed this up, Judge.
That's something else.
But the point is, the court says that he erred in relying on those transcripts rather than hearing those witnesses themselves. And there is a procedure. We'll go up there, I've domesticated a subpoena, we'll go. If he doesn't show up, then we'll take it up with Your Honor. Maybe we get an order and we go to Virginia and we rule him in. There's a procedure to get Blaze Ward. They're not doing it. They won't Blaze Ward. Blaze Ward didn't see anything. But there's a way we can get these people. But to sit here and say we can't get them, we called them, I don't think that that's the way to do it. I don't think we ought to call them. I think we need to use the procedure that's available. Serve them with subpoenas. They fail to comply, we rule them in, and then we deal with it. And ultimately, I think we get it, because nobody's going to go to jail. And hopefully it doesn't come to that. So hopefully common sense prevails when we get there.
That's where I want to get. I want common sense prevailing, and they disappointingly come and present testimony truthfully. That's what I'd like to see. I don't want to bring them into duress. I'd like to get them to come can testify and let y'all present the case through them. Notwithstanding these 911 calls, are certainly additional things they said, and y'all know that can be used to them too as well. So, all right, let's get these tapes, or recorded, not tapes anymore.
Yes, what do you want to hear?
It's just gonna play through the, audio.
It is, Judge, if you can't
I
hear.
kept pointing that TV over there like you gonna let me see something, that's not the case.
Well, on the 911 calls, we don't have anything with audio.
That's what I was thinking, I wonder why you kept pointing the TV.
Some of the other statements have some body cam footage, but that's not, I mean, our motion really is about the written statements they made, and also, the 911 calls. They describe portions of the statements made to law enforcement in 911 calls as testimonial, and some as non-testimonial. Well, the non-testimonial portion of it is the excited utterance and present impressions. I'm going to suggest to you there's both in that call. There's both testimony and non-testimonial. Thirdly, when we get to the latter half of the call, when they're asking questions and she's responding, that's more like testimony. That's not treated the same way. But the beginning of the call is a present sense impression. It's exactly what the case law and the rules contemplate. Her contemporaneous narration of the events are exactly a present sense impression. And there's no question that she was making excited utterance at the time she was doing that. Now, we will stipulate that we think there's some things that she stated that aren't factually correct. For example, we don't have any indication that there were bullets hitting Mr. Boyd's truck. We know that the glass you saw flying was coming from bullets that were originating in Mr. Boyd's front seat and going outward. They're defensive shots. And so we think she made a mistake. That doesn't mean that her call, her narration is not credible, is what she observed at the time. What it means is she made a mistake. She didn't interpret that correctly.
Didn't some of her comments allude to her concern about the driver of the white truck, which would be the following truck? I mean, she was concerned about him, and couldn't see the black one.
Absolutely.
Don't know where he is, he may pull away or whatever, but she was concerned about the driver of the white truck
And
because
she
of what she perceived as shots that way.
Exactly. And so we believe in the standing ground hearing, in the bench trial setting, under the Brown versus Allstate analysis that the appellate courts have given us, that you can discern as a fact finder in a non-jury setting of what's testimonial and what's non-testimonial, and what you can rely on and what you can't rely on. We believe that you're well qualified to do that. And we'll have the same kind of comments about Mr. McMurray's call as well. His is a little shorter. Now, if you have any questions, I'll jump right into it. If there's anything you want me to respond to, I won't.
I picked up on her difficulty in seeing everything. She wasn't looking at the whole thing, she was looking at a partial part of it, and her perception is perception.
Right, let me just say, I don't know that I agree that portions of it are testimonial. I think all of this is, and I know where he's coming from, because the 911 operator's asking questions and she's answering. But this is dealing with an ongoing event. It's not preparation for trial down the road. And so I think that's the difference in testimonial and non-testimonial. And secondly, I think it was difficult for her to see what's going on. But in terms of being truthful or not truthful, she talks about, I seen bullets hitting the windshield. Well, they are. And little shards of glass are flying. She's telling the truth about that. She don't know whether those bullets were being fired into or out of the white truck's windshield. We do know from the rest of evidence around it, Mr. Spivey fired 10 or 12 shots towards that truck. Doesn't seem to be any evidence he hit it, but when she says he shot, he was shooting. So you can quibble about what the nuances of what she said, but you can't help but get the impression that young lady's doing her best to tell what she saw.
Right.
This will be Mr. McMurray's.
All right.
Judge, I would ask you before they play that, or suggest that now or at some point in time you read Blaze Ward's written statement, just for context in terms of if she's consistent or not.
Well,
The other call that we came prepared to play is my client Boyd's call. He will be in the courtroom and of course been authenticated in the courtroom. So I don't know if your judge has to rule on that one in this motion because he'll be able to authenticate it while he's testifying. But as to Mr. McMurray's reaction, and I cited this in the memorandum, I cited the Hendricks case, 408 SC 533. Mr. McMurray's reaction was such that it generated the spontaneity that gives an excited utterance an inherent reliability. Now, I'm not suggesting to you that everything he said was accurate, and I acknowledge that some things he was stating were relayed by others that were in his presence, because you could hear them. But as to the first part of the call, he clearly was stating what he observed. And we believe we could parse it out, just like Ms. Ward, if you gave us guidance, and we could provide only parts of it. But we really believe in the non-jury setting, you can determine what you can review and not review based on the...
I heard the change of, when somebody came up and says, the black truck's been following or something, another truck. The tone of the conversation changed to that point forward.
In fact, you heard my client's voice in there too, because he was talking to my client. So we're not going to try to use either Ms. Ward's call or this call for the improper purposes of having you rely upon hearsay upon hearsay. But as to their present sense impression and as to their excited utterances, we believe the rules and the case law that's set forth in this memorandum absolutely support the admission. So again, if you tell us you want us to go parse out things, and we'd have to get some technology assistance, but if you tell us that you can determine what you can hear appropriately and what you can't, or consider in your ruling, which I submit to you, we believe you can, we would accept that guidance. But now, after this, we've got body cam footage of them talking to the officers, and we've got also, they were given a piece of paper, so it was you write a statement, and they wrote this statement out.
Now you hand me the other, no, got it.
Mr. Martin did.
Okay.
And I submit to you that in the case law, you know, we know that statements that are made as much as an hour later have been admitted in our South Carolina jurisprudence as excited utterances. And we know that in cases where it's been more than a day, they've not been admitted. And so there's some bookends, if you will, about what's permissible and not permissible. But I suggest to you that these handwritten statements were well within a 1 hour time frame that our case law supports.
Martin, you got something?
Well, you know, I hate to differ too much with Ken, but I think the entire statements are admissible. No parsing out hearsay with a hearsay, I don't think is applicable here. You did hear what sounded like another guy walked up and said, black guy was chasing him. I don't think that's hearsay within hearsay, because there were 1, 2, 3, 4 witnesses who gave statements, and we hear in court that said the same thing, that the black guys harassing him, chasing him down the road. So my point is, this is a 911 call, which overrides the hearsay within hearsay when somebody says a statement like that. Now, the court feels it proper to parse it out, but I think, again, the court in this instance, State versus, Brown versus Allstate, can hear this and determine what is relevant and what is admissible to you in making a decision.
Judge, there's no black guy involved in.
It's a black truck.
Yeah, black truck, but there's no black guy. And it doesn't change the fact that you still have to perceive it. And it's hard to respond generally, so I'm going to respond specifically. Blaze Ward, you hear her say that she only saw, and what you'll hear if you get into the other statements, she will expound on what she saw was simply the glass flying. She and Mr. Boyd had exchanged messages that were downloaded from his phone when SLED did the download pursuant to a search, a consent to search. And on that second page, she even tells him, I had no idea if he, Scott Spivey, jumped out or parked in the middle of the road and started shooting out the window, because at that angle, all I seen was the glass flying. That's all she saw, Judge. That's all she saw. And look, They can talk about this Allstate case all they want to. The court has made it clear, we take seriously the use of deadly force. And the legislature didn't give the court any guidance on how to do these things, and so the court has developed procedures. But if you and I get into an altercation and only one of us is left at the end, that person's credibility is on trial. The trial judge who hears and determines this in a non-jury setting has to decide. And so you can't say, well, Judge, you just listen to this and adopt this as true, and it's clear she did not see bullets hitting that car. Does she believe she did? Sure, she believed it. Was she afraid? Sure, she was afraid. Doesn't change the fact that that's not what's happened, and they're offering it for the truth of the matter asserted. And that's not an exception to hearsay. And so, I only go back there because that's where they started. I think that State versus Dennis in the McCarty case clearly define what this court has to do. And you have to see them. You have to hear them. And we have to judge, and I get to cross-examine them on these statements, and I get to cross-examine her on saying, I didn't see it, I couldn't see it, I wasn't there, and show the video. But that's not what's happening today. What's happening today, sure, you can listen to everything. You will see everything, no question about it. And you will use your discretion and discern, but you don't have the discretion to rely simply on this and allow them to present this case, which is their burden to bear, in the fashion that you're trying to do it. That's not what you have the discretion to do. You will ferret out what should be relied on and what should not be. They can't do it this way, and that's what State versus Dennis says.
Well, I won't get into the case now, but I fully disagree. That is not what State versus Dennis says with regards to what we're doing here today. That was a totally different case, totally different situation, apples to oranges.
Well, the difference in the Dennis case particularly is that the witnesses were students. They weren't named, just video, and they were in the video. They were recognized by other witnesses during the first trial, so it's not like they called and there was a recorded conference or anything like that. They were just kind of unaware of who it was. And once they were made aware, what did you see, where were you standing, and those questions went through the second time. So it's a little bit distinguishable in my opinion. The two Dennis hearings with what Judge Hood did, and I don't know.
Well, that, again,
I know the Dennis case included some videos that had some audio, but it wasn't a 911 call that was being recorded. It's totally different.
right, former transcripts versus a 911 call, apples to oranges.
Well, the court says that it was error for Judge Hood to use the transcript of the hearing of the original stand your ground hearing. And he said, we're not going to have a hearing, but then he proceeded to have a hearing, and the state put in additional witnesses. But that was the error that was assigned by the court. And if you go, and they cited a Georgia Supreme Court case where the same trial judge had held the original hearing 8 or 10 years earlier. He saw the witnesses, and our court said that was important because he saw those people testify.
I agree with you on the credibility situation, but the people that didn't testify, there was no testimony offered in the prior hearing of any type, recorded, unrecorded, or written statement. There was nothing offered by the witnesses who every party was unaware of their names.
Well,
So it's a little distinguished from that fashion. It's just, it's not the same.
But that went
Nobody
to,
called 911 and they played that tape because they were unavailable. That didn't happen in the Dennis case.
no, sir, but then that goes to why they were allowed to have a second stand your ground here. At first, it was a mistrial, so the mistrial was a do-over, so it essentially started over. But they had these new witnesses, which is why the court said, oh yes, they were entitled to a second stand your ground here. But it was an error for Judge Hood to have relied on the transcript of the first hearing in doing that second hearing.
And you're stating that what happened in this case correctly. I'm not certain I agree that I think they're slightly distinguishable.
Well, and again, I know you can judge the credibility from the 911 call. It doesn't say you got to look at a witness in a courtroom. You got credibility as an issue, does she sound credible or not? You judge that for what it is.
I would add to that, I am certain that Attorneys Tinsley and Hannah can point out any inconsistency in those calls, in those transcripts, in their argument in opposition to the standing ground motion, even if we don't have witnesses here. Hopefully we'll get them here. But if you give us a date, which I think you're inclined to do, and we're ready for it, if we can go forward with these calls. If we can't go forward with these calls, I don't know when we might get them.
All right. I'm gonna study this. Well, I am.
Well, Judge, in fairness too, I mean, them not being able to go forward, I get we're in a civil case, and it's dramatically different than a criminal case where the state already has the evidence and already given it to the defendant. But in my mind, this is a lot like a summary judgment motion. You can't rush me in here and not give me discovery, not give me the deleted Facebook messages for how many months now, and expect me that now that we're up on Thanksgiving, we're gonna be ready on December the 15th when they know I'm going to get this witness who saw my guy shot down in the road. We're not gonna be ready by December the 15th. Regardless of what you do on this call, there's no way that we can get there. And I think that I'm entitled to the evidence, I'm entitled to go and depose these witnesses, because it is tantamount to a summary judgment hearing, in my opinion. It's not a motion to dismiss where you're ruling solely on the pleadings. You are this is a full-blown evidentiary hearing. And if there's ways we can short circuit it by presenting video depositions, or when we don't object to some witness's testimony and we give you the transcript, I think we have the ability to do that. But thus far, even though we started talking about this in June, I haven't gotten anything other than what he filed last night, and I haven't had a chance to see it.
This case, our posture now is nothing like a summary judgment motion, and I think that's what counsel is trying to have this court believe. The burden is very different. It's a very different analysis of summary judgment. The court's called upon, as you know, to be the fact finder.
That's not.
Preponderance of evidence is our standard. There's nothing about this case that's like a summary judgment.
I'm not suggesting that. My analogy to summary judgment was in the sense that it's premature until I have an opportunity. Summary judgment wouldn't be right until the discovery is complete, at least on these issues. I thought we had originally agreed to limit discovery in this case to the standing ground issues. But I've been met with obstruction and I haven't gotten this information. We're trying our best. We got Thanksgiving, we got December. I've offered to pay for a court reporter so we are not stuck with whatever court administrators can give us. I will still do that, so we have some leeway. And I want to get it done as quick as possible. I'm ready for this to be done, so we can move on.
All right, going back to the expert that's transcribing or working on the instant messages. Can you look in and let us know, everybody know, what his timeline is getting that transcript, whatever you call a transcript of the message prepared?
I can certainly do that, and I'll endeavor to have you respond by tomorrow. Everybody responds.
Right. All right, well, here's my thing, is I got a rule one way or the other. If these come in, regardless of the presence of witness, if these only come in, if the witness is present. That's one of the two. And then I discern, if it's a bench trial, I discern what I believe is relevant, or what I believe to be hearsay, or whatever. It's not probative to my issue, and I've got to decide. Simple as that. So, I think I can read over this, and I'll give y'all a decision very promptly, probably this week. You all know what I'm gonna do. The messenger's analysis, that's he's entitled to that.
And,
Just based on what y'all said, I think it's a piece of shot that he gets that deposition.
on the messenger analysis, I agree, entitled to it. Under our confidentiality order, I'm to mark those confidential if they'd be considered under that order. But we had prepared the expert to provide them directly to the opposing counsel as opposed to coming through the defense counsel. We keep marking it that way, and they're electronic. And so I certainly don't, I will undertake the task to get them done with this expert, but I would ask the court to, ask for a stipulation or order that they will be subject to the confidentiality order when they're turned over. I don't want my
I
client.
think in everything, we've been subject to the confidentiality order, we're gonna stick with that, we're not gonna have some stuff confidential. All by the same, we're gonna consider everything under the same glass. I don't see the reason to change that, well, these statements are one way and these are another. They all come in admissible or not. Since the fact finder's only one person, we can wrestle through that.
Yes, sir.
That's not gonna be a problem, but
If
if you can get them to him and he can see them, subject to your objections, that's confidential, but he can't, but till we get that done, the quicker he gets them, the quicker he knows at least what he's dealing with. And I would presume, since the conversation between y'all's two clients, that a lot of what you're gonna find, he's already seen from the other side of the conversation. Am I wrong on that?
No, that part, you're right. It's broader than that. But there's a way, and in the request, it has the protocol for doing the download. And not only do you get the stuff that they deleted, you see the history of when they deleted what. So the whole idea, we gotta get an expert, so we got this other disinterested party who's a witness. The history itself basically self-authenticates and tells us when and what was done in the history. So I don't think it's necessary, but if they need somebody to do it, that's fine.
Okay, well, y'all get it done, but it seems pretty obvious if it's given time of what was done when the editing was done, if you wanna call that deleted editing. I mean, you can edit anything on your phone and computer these days. All right.
Two things before you leave us, you know. One is, does the court have any preference as to how they wish us both to proceed again with regards to Blaze Ward and McMurray getting in here? Because he's, may get some answer, but if I'm Mark, I want McMurray, or if I'm, and we would like to get McMurray too with the other one. Their promise to come would be worrisome if there weren't some order there.
Just to be clear, I don't think we can make him come here. We can compel his attendance at a video deposition in Virginia and then use that here in the trial in accordance with the rules. And I would assume the same thing with Blaze, unless you catch her in South Carolina. But she works over here, so you could probably catch her.
Well, and maybe neither one's necessary. I think a judge in Virginia could order him to come to South Carolina. Used to prosecute criminal cases, they can't, judges can do things like that all over. But I guess we can see what happens December 1st with regards to that deposition. But I didn't know whether, you know, if you, with regard, let's say Blaze Ward, any way you prefer we approach her, or what efforts we take to get her here, what timeline. All of that may fit into whether you let these statements in and when you set the trial.
Certainly y'all contemplated what you could do.
Well, we have, I mean, I'm telling you.
Yeah.
Transparency being what it is, we want them both here, okay? But, I don't know, we think the 911 calls are admissible, and they're frankly, or that testimony is necessary to tell the facts about this case. And I think everybody wants that.
There were some parts that those calls where they gave personal information. Some of that information may already be out there. It certainly does need to be republished after this hearing.
And her phone, Blaze Ward's phone number doesn't need to be published.
That's what I'm talking about.
Yeah,
The
yeah.
address, phone number, something else. I don't remember what else it was. License tag number.
Make and model the car, Jeff.
I mean, it's just, there's certain things, black Chevrolet, okay, white Dodge, or Ram, whichever it was, maybe the same thing. We don't need to be posting people's phone numbers, because it may ramp it up and these people go deeper in the hole. And we can't, I'm gonna say coax them out. I want their cooperation without.
And I think,
And I think we can get that if they understand how important it is for them to come to assist the court, me in particular.
The problem we've had so far, just can't get any communication with them.
yeah, and that's what I was gonna say, is I hear you, and we'll keep trying, but at the same time, I'm of the impression, I think everybody is, we were at a point in this where we've tried every other way. Frank McMurray has gone as far as to tell Mr. Tinsley, he's gone and got himself a lawyer, he wants us arrested for harassment, he ain't doing nothing. Blaze Ward similarly has done the same thing to both of us. I personally think, absent a court order or a law enforcement escort here, they will not willingly participate. So given that, that's the reason why we wanted to address this issue in anticipation of that. But at what point, you know, at what point does the court say, listen, we're gonna have to move forward without them?
There's one possible way short of that, but, because we have tried. Mark's written a nice letter, he's written an email letter, Brian and Mark wrote one together.
I didn't write a meeting.
I called, well, he wrote a letter that said, we'll have to take the next step if you don't comply, and that might have been interpreted as offensive by some, but I mean, it wasn't mean, other than it said, we will take.
So he can say where else.
I wrote the letter, Judge, I wrote the letter, and it basically said, the letter just basically says, we really like your cooperation, but, and Mark, me and Mark together worked on that and he signed it. If we don't get it, we are gonna have to go back to the court and take further measures to try to get your cooperation. And that was met with
Less cooperation.
less cooperation.
So the less intrusive alternative to an order, which I think an order probably would require, is, you know, my understanding of the rules and the canons are that the court can't have communications that are substantive. But I have no objection to the court having the clerk or your honor try to contact them. We can provide the information and see if they will communicate with you, knowing you're a judge. Because what we do want to do is try to solicit their cooperation. And so from Mr. Boyd's standpoint, if you wanted to try just to determine for yourself whether or not it's possible, I would have no objection to that.
And not with Williams.
Well, you don't have a problem with that, but
No.
I'll study that as well. We'll figure, I mean, I sure would like them to come. And I'd be very proud to have them in this courtroom.
Well, we may make another run at it with some sort of private investigator.
I think that's the problem, Judge.
Well, then how you gonna get to them?
You certainly
How about let's you and I
investigate your
let's you and I drive up together and see
I'm
Blake.
driving up there December 1st.
I mean Blake Ward now. You wanna listen to the
No,
You not good?
Y'all can be witnesses, I'm not gonna be a witness. Let's serve her with a subpoena and take her in and we'll get her testimony.
All right.
One last thing before we go. David Jordan, the county attorney, is here. And I had asked him about giving us a time we could all go look at this evidence. And we haven't arranged that, but I think David is happy to talk with the court about, and maybe we could get the court to convince the county that the thing to do is let us all go look at the evidence together, I guess.
I don't know what you're talking about.
The evidence,
What evidence?
the bullets, the guns, the things that.
The guns are gone, they gave the guns back.
Well, the bullets aren't gone. There's evidence at the Horry County Police Department that you or I may want to put into the record. And so I always like to go look at what's there. Now, obviously.
Oh, I didn't know what you're talking about.
Yeah, that's what I'm talking about. We're trying to set that
Since these damnable podcasts started, this tip trashing, I haven't gotten an officer to respond to my call yet. I think there's some gag order by the county over there, and I'd like, if there is, for Attorney Jordan to speak to it, because I've never had a case in 29 years doing this, or 28 years, however long it's been, where I could not get any officer to even talk to me. And I think you've been met with the same thing at Mr. Mark.
Well, if they, you
So
know.
is any of that what y'all are feeling, you may not know, relating to the misconduct investigation to the Horry County officer involved in this thing? Is any of it got related to that?
We don't know.
They're told not to say anything?
That's probably what it is,
Probably.
Judge, but David's here, he can tell you, he can
Your
tell you
Honor.
what the deal is.
David Jordan, if I may.
Come on up. Get in, Fred.
Yeah, I was just coming to watch, and Mr. Martin grabbed on the way in. So the county's position has always been, at least since prior to my, or my predecessor's position on a civil case, we take written questions for our employees to prevent looking biased, which this is a civil case. So that's how we have
But
met
what
this.
they asked was, can we arrange a time, particular date and time for these lawyers to come and peruse the fiscal evidence y'all?
We would be more than happy.
possession And not ask anyone a question.
Yes, sir. And we would like to do that with all of you at one time.
Do you have,
I do.
you still have evidence? I mean, because I know that Solicitor Barnett is looking at it, I know that he was meeting with SLED today. I don't know what the status of that is in terms of what they're doing, but,
I'll be glad, well,
yeah.
if I can, reach out to Solicitor Barnett. He's the secondary.
I think he
reviewer.
just has copies so far.
Correct.
So maybe they have whatever they haven't released.
And I haven't been asked for anything specific.
I didn't
I
think so.
don't know what harm could
Just
come
in
to
general.
y'all
Yes, sir.
as a group of lawyers to go in some conference room and look at the fiscal evidence they still have in their possession and give a look at it.
That's all I'm asking, and they got it.
Yeah, whatever we have.
I think that's plausible. And there'll be no employees questioned. The analysis will be, here's what we got,
That's good.
and y'all look at it.
Well, you got a date in mind, or you wanna give us a couple of dates?
Let me grab my phone.
I think that's a great idea. Let's go look.
I guess, what's good for you?
I don't know, I'm gonna pick me a witness there, I'm not gonna be a witness. And Morgan's chomping to be a witness, but I'm not.
Well, somebody can come.
I don't think I understand what you're talking about, but if it makes me a witness to go look at the evidence,
No,
I'll
no, I'm
become
not.
one, so, whatever.
Well, y'all pick your date and time.
Okay, we can pick it whenever. Sure. We can talk
I'm
after.
gonna suggest y'all get that done next week.
Thank you, Judge.
Hey,
Thank you.
All right. Anything else, we'll collect it here, we'll cut the web out, y'all.
no,
All
sir.
right, that concludes this hearing.